Welcome to the United States Patent and Trademark Office webinar series for experienced practitioners. My name is Marisa Terrell, and I'm an attorney in the Trademarks Customer Outreach Office, and I am pleased to serve as your host today. As an experienced practitioner, you probably have prosecuted trademark applications for marks involving catchphrases, memes, or even t shirt imagery. In today's presentation, Trademark Trial and Appeal Board judges Thomas Casagrande and Catherine O'Connor will discuss the history of failure to function refusals and how to respond to these refusals effectively. But before I introduce our subject matter experts, I'd like to share a few announcements with you. This session is being recorded for your convenience and captioning is available. We'll post a recording, we'll post a recording of the webinar on uspto.gov and on YouTube in about 3 weeks. You'll also receive a copy of today's slides. Check your email now and at 3:30 p.m. Eastern Time for a message from Salesforce with a link to our slides. Throughout the presentation, our event producer, Jay, will also share a link to the slides via the chat window. And you can access that chat window by looking to the bottom right of your screen and clicking on an icon that shows three dots. You will see a chat box and a Q&A box that will pop up when you hit those dots. Please notice that the links in the chat thread are not going to be live. Therefore, in order to access them, you'll have to copy the link and paste it into your browser. One more comment about the chat window. Please be aware that the chat thread is for announcements only and it's going to be disabled during today's presentation. After the slide presentation, time permitting, we will open up the discussion for questions. So please submit your questions via the Q&A window. And how will you do that? Simply type your question and hit enter. As always, we've got a record number of attendees today, so it's possible that we may not get to all of the questions. Please be patient with us. At this point, I'd like to go ahead and introduce our two expert presenters. First, I have the privilege of welcoming Judge Thomas Casagrande. Now, before becoming a judge, Judge Casagrande was a U.S. Patent and Trademark Office Associate Solicitor, where his responsibilities included defending TTAB decisions at the Federal Circuit and in U.S. District Courts nationwide. Before coming to work at the USPTO, Judge Casagrande was in private practice for about 20 years, focusing on trademark litigation, counseling, and patent and copyright litigation. He practiced in Houston, Texas at Arnold White and Durkee PC, which later became Howry LLP, where he was a partner for 8 years. Judge Casagrande earned a BA from the University of Pennsylvania and his JD with honors from the University of Connecticut School of Law, where he served as executive editor of the Connecticut Law Review. Immediately after law school, he clerked for Chief U.S. District Judge B. Avant Edenfield, Southern District of Georgia, Savannah Division. I'm also pleased to introduce Judge Catherine O'Connor. Judge O'Connor started her career as a law clerk for Judge Denny Chin, then a U.S. District Judge for the Southern District of New York, where she worked on various intellectual property matters, including patent, trademark, and copyright cases. She then spent nearly 28 years in private practice at the law firm Day Pitney LLP, litigating all types of intellectual property cases and advising clients on securing and protecting trademarks both in the United States and internationally. During her tenure at the firm, she assisted clients ranging from startups to global companies. She was a partner at the firm from 2017 until she joined the TTAB in 2024. Judge O'Connor received her BS in Business Administration with a concentration in marketing from the University of Connecticut, cum laude, and her JD, summa cum laude, from St. John's University School of Law in Queens, New York, where she served as executive notes and comments editor of the St. John's Law Review. Now, let's go ahead and welcome Judge O'Connor to start the presentation. Please proceed, Judge. We're ready for you.
Terrific. Thank you, Marisa. And thank you, everyone, for joining us this afternoon. I'm delighted to get us started in our discussion. Today, we're going to review a few aspects of failure to function refusals and how they have been addressed in TTAB proceedings. Before we dig in, I'd like to give a brief overview of the topics we'll be discussing. First, we'll review the statutory basis and history of refusals to register based on failure to function as a trademark. We'll do this largely in the context of the informational matter type of failure to function, which offers a useful reference point to trace the evolution of the case law. Next, we'll review the board's current practice and recent precedent relating to various types of failure to function. Our goal here is to provide a sample of the types of refusals that we have been seeing in this area. We'll also consider how failure to function relates to other types of refusals, as on the grounds that a proposed mark is merely descriptive or generic. Then we'll conclude with some practice tips and, time permitting, address viewer questions submitting during the program. So with that, we'll get into the content. As experienced practitioners, you've surely faced refusals to register a trademark for different reasons. If you've not had an application refused due to failure to function as a trademark, you may wonder where that ground originates. Like other grounds for refusal, the statutory basis is found in the Trademark Act. In fact, it's in the very definition of a trademark in Section 45, which states in sum that a trademark is any word, name, symbol, or device, or any combination thereof, used or intended to be used by a person to identify and distinguish his or her goods from those manufactured or sold by others, and to indicate the source of the goods, even if that source is unknown. Thus, again, under the statute, a proposed mark must identify and distinguish the goods and services of the applicant and indicate the source of the goods and services. If the subject matter of the application primarily does something else, it fails to function as a trademark. Sections 1, 2, and 3 of the Act use this defined term in providing for registration of both trademarks and service marks. This concept is nothing new, as reflected in the often heard quote from the Standard Oil case that you see on the screen. As the Federal Circuit's predecessor court reasoned there, if the ordinarily understood meaning of the words conveys information other than identifying the source, then the words do not function as a trademark. This was recently reiterated by the Supreme Court in the Jack Daniels against VIP Products case from 2023. After noting the broad scope of the first part of the definition, the Supreme Court went on to state the second part of the definition describes every trademark's primary function to identify the origin or ownership of the article to which it is affixed. Trademarks can, of course, do other things: catch a consumer's eye, appeal to his fancies, and convey every manner of message. But whatever else it may do, a trademark is not a trademark unless it identifies a product's source. This is a Nike, and distinguishes that source from others, not any other sneaker brand. In other words, a mark tells the public who is responsible for a product. There are multiple ways in which a proposed mark can fail to function as a trademark. In addition to informational matter, these include matter that is only used as a trade name, is merely ornamental, is the title of a single creative work, and the like. In the TMEP sections on the slide, you'll find information on each of these types, and we'll touch on some of them when we discuss recent board cases a bit later in the program. Failure to function has similarities to other grounds for refusal. Refusals based on a term being generic or merely descriptive can be considered types of failure to function by other names, as these are all ways that a purported trademark may be perceived as primarily communicating something other than source, such as the genus of the goods or one of their features. The source identifier requirement is broader than just whether a proposed mark is generic or descriptive. So with that background, I will turn it over to Judge Casagrande to walk us through the history and current practice of failure to function as it relates to informational matter.
Thank you very much, Judge O'Connor, and welcome to everyone. What I'm going to do is talk about failure to function in the context of informational matter refusals, one of the longest standing types of refusals for failure to function. Traditionally, this refusal focused on merely informational slogans and terms, and common laudatory phrases or statements that are ordinarily used in connection with a business or a particular industry, or perhaps the goods and services that are identified in the application. And I'm going to go through a number of cases that sort of begin in the 1960s. And as I go through these, what I would like you to do is kind of think to yourself, how do these particular cases compare to a typical descriptiveness case or a genericness case, which are specific kinds of failure to function that are kind of related to the broader failure to function. And in particular, try to look at these and think about how they differ from descriptiveness in the sense that these marks that people were trying to register were only loosely related to the goods or services that were identified. In other words, they didn't have the sort of immediate connection that you would expect for a descriptiveness case or a genericness case. So for example, in the medic alert decision by the board, identification tags were the goods, and the mark that they sought to register was medic alert, and the refusal was affirmed because that wording serves only to direct attention to the fact that the wearer of the tag has a medical disability. Um, and the Standard Oil case that Judge O'Connor talked about earlier, the mark there was guaranteed starting for services identified as servicing motor vehicles for use in cold weather. And in that particular case, the court said that the wording there is merely a condensed announcement of a guarantee that the car will start. And these sorts of refusals continued on through the 70s and early 80s. For example, in the O.R. Mossberg and Sons case, there was a phrase, more gun for the money, for goods defined as firearms. And that refusal was affirmed because that, again, was a wording that was informational relating to the products that are sold and that they're sold for less money than competitors' products. In the Niagara Frontier Services case, this was a case where, if you read the board's decision, it was based not only on what the phrase means, and that it's an informational phrase that you can take things from this supermarket and bring them home and bake them, but also it was based on the specimens in that case, which showed that that particular phrase was not being used in a source identifying fashion, but that other things in the specimens were being used in that fashion. So this was kind of a combination of the meaning of the phrase itself and the way the applicant was using it. The Tilcon Warren case involved goods that were described as construction material, including crushed stone and concrete. And with the mark, watch that child, that was used in connection with that. Another, again, this was affirmed. The wording there was said by the board to be merely a familiar safety slogan that the company wanted to have in connection with its goods and services. A few more as we go through the 1980s and 90s of informational matter refusals were the Wakefern Food case, why pay more for supermarket services, and the Melville Corp brand names for less for retail store services. And these were both refused because this wording was just common informational merchandising slogans in both instances that were used by many types of people offering competing services. The Manco case, this is kind of like the Watch That Child case I just mentioned. The phrase was think green for household packing and insulating materials. The wording broadly conveyed the ecological concerns of the environmental movement, which the applicant wanted to associate itself with, and therefore wasn't viewed as a source indicator in that case. Proudly made in the USA, and we've seen there are a couple of these that are more recent, but the Remington products was the first one that was being used for electric shavers, and that wording just informed the public that the applicant manufactured the product in the USA, and that they were proud of doing so. Another one similar to Watch That Child is the Volvo Cars case, which was Drive Safely, which they were using in connection with sales of automobiles. And again, the wording there was viewed on the evidence in the case as just a commonplace safety admonition. Uh, in the, I think it was 1998, the Federal Circuit actually had what is I think the second case since the one back in 1960 that Judge O'Connor talked about. And this 1998 case was Boston Beer. And in that case, the phrase was the best beer in America, which was viewed as so laudatory and highly laudatory and descriptive of the qualities of the product that the slogan does not and could not, and I'm quoting from the court now, does not and could not function as a trademark to distinguish Boston Beer's goods and serve as an indication of origin. So that's that's an instance where you're probably thinking that is pretty descriptive. They actually mentioned how descriptive it was and how laudatory it was. So this shows how these particular failure to function for merely informational and descriptiveness refusals can somewhat overlap. And now I'm going to talk about some of the more recent developments in this area of failure to function. Uh, as again, as you've seen from some of the historical cases, common general fact patterns involve people who are trying to register phrases that give general information about the goods and services, but maybe not quite specific enough so that they would be seen as merely descriptive. Another common general fact pattern, and one that's becoming increasingly commonly seen here, is a common phrase or a widely used message that someone is seeking to register. And related to that, some of those common phrases are, for example, direct quotations or passages or citations from religious texts that are used to show affiliation with or support or endorsement of the ideals conveyed in the text. Some of the widely used messages, as I mentioned, involve slogans, terms, and phrases that parties use to convey ordinary or familiar concepts or sentiments. And some of them have social, political, or religious significance. But again, these are all phrases that could, under the evidence in the case, be seen in the cases, be seen to be something that fails to function as a mark because it merely conveys to people these particular informational phrases. I'm going to now give you a few of the key sort of case quotes that you'll see repeated in a lot of the board decisions because they kind of set forth some of the basic law in this area. And in the recent 2020 Team Jesus LLC case, the board said, and this was a case, by the way, that involved the mark Team Jesus for clothing and educational services. And the board said there, matter that is widely used to convey ordinary or familiar concepts or sentiments or social, political, religious, or similar informational messages that are in common use would not be perceived as indicating source and is not registrable as a mark. Another case that you'll find board decisions tend to cite frequently is the Proline case. And in that particular case, the phrase was blacker the college, sweeter the knowledge. And the applicant was trying to register that for clothing. And in that case, the board said, not every word, name, phrase, or symbol, or design, or combination thereof, which appears on a product, functions as a trademark. And the mere intent that a phrase function as a trademark is not enough in and of itself to make it a trademark. Instead, what we need to look at is evidence of consumer perception. How is that word used out in the world? And what does the evidence show that people will take away from that? Will it be something that's associated with the applicant exclusively, or is it something that people associate much more broadly and not with any one particular party? The recent Greenwood case from 2020, That involved Lee Greenwood, who I think is the author of the God Bless the USA song, and that was the mark in the case as well. And that was being used for goods identified as accent pillows and decorative wall hangings. And in that case, the board said the more commonly a phrase is used, the less likely that the public will use it to identify only one source, and the less likely that it will be recognized by purchasers as a trademark or service mark. So the basic inquiry in these cases is that the USPTO looks at is how to assess the evidence of that the relevant public would perceive that the mark is communicating. Does it perceive it as something that identifies and distinguishes a source, or is whatever the words or design is that communicating something other than identification and distinguishing of a particular source? So, for example, the Team Jesus was a case in which there was a lot of evidence in the case that various third parties were using Team Jesus on similar goods and related goods, just as the applicant was. What we want to do is try to assess the perception as a source, looking at the evidence. How do third parties use the phrase? Because that's going to be what the consuming public is going to see out there in the world. And also, and this is kind of related to the case I discussed earlier, where the phrase was, "We make it and you bake it." There was evidence, is there evidence that the applicant themselves are using the phrase not as a source identifier, but to impart some other kind of information? So how does Section 2F, which allows for secondary meaning or acquired distinctiveness to be used to overcome certain kinds of refusals, like the refusal for mere descriptiveness under 2E1, how does that relate to failure to function claims? Well, generally, and we'll talk about this, and Judge O'Connor in particular will talk about this a little further on, a 2F cannot usually be used to overcome failure to function for most kinds of failure to function refusals. But that doesn't mean that type of evidence is irrelevant. As you've heard from what we were talking about before, we do look at evidence of how third parties are using a particular phrase, and that might sound familiar to you in the 2F context, because if a lot of third parties are using a phrase similar to how the applicant is, that generally goes against the kind of exclusive or substantially exclusive use that we would expect from an applicant who's trying to prove that they have acquired distinctiveness in a mark. So that type of evidence very generally relates to consumer perception. And so even though you may be familiar with that in the 2F context, that is something that we will look at in the context of a failure to function refusal. So for example, this refers to the Ocean Tech case from 2019. That's a board decision, if you recall seeing it when it was published, that involved a fairly multi-component mark that involved the term 100% crab meat and a very photorealistic depiction of a crab. And that one was refused, and the refusal affirmed by the board for failure to function. I want to talk about a couple of recent Federal Circuit precedents, because they are the ones who give the authoritative law that the board and the agency must follow with respect to registration issues. Two of the more recent ones, the one from 2 years ago is the Vox Populi registry case. And in that particular case, the mark was .sucks for services described as domain registry operator services for .sucks domains, and for domain name registration services, again, for .sucks domains. And the court there held that the evidence supported the board's refusal, and the court said consumers will view the standard character mark .sucks as only a non-source identifying part of a domain name, rather than a mark. And if you look at that, I mean, that's another example of a case where you wonder whether or not how closely that aligns to a potential genericness refusal. But in that case, only the failure to function refusal was made. The evidence there showed that the website itself was using .sucks to refer to a product. There were online third-party articles discussing .sucks as referring to a product rather than to the provider of the services in the application. And there were third-party registrars who were using .sucks to refer to the product that they were selling that would then be listed on the applicant's registry. So there, the evidence was pretty overwhelming that the public looking at that would not view that as a source indicator, but rather as the thing that the services were relating to. A more recent one from earlier this year is In Ray Go and Associates, and it involves a very common, at least currently very common type of proposed mark, where it's a commonplace slogan that many people would like to align themselves with or show support for. And this particular applicant was trying to register everybody versus racism for goods described as clothing and tote bags and race-related informational services. In that particular case, the board or the court actually compared the failure to function refusal with generic or descriptiveness and said the source identifier requirement, and in that it was referring to Section 45's definition, is broader than just whether a proposed mark is generic or descriptive, and typically focuses on how the mark is used in the marketplace and how it is perceived by consumers. In that case, the evidence showed that third parties commonly use everybody versus racism or something very similar to that in an informational and ornamental matter on similar types of goods to what was identified in the application. Clothing items, tote bags, retail items sold by third parties, all to convey an anti-racist sentiment. And so consumers, looking at that evidence, the board said, consumers would not view this particular phrase as an indicator of a unique source. Two recent and frequently cited TTAB precedents that basically are riffing on the same kind of refusal are the DC1 wholesaler, which is I Heart DC, used on the sort of goods that you would expect to see that on: clothing, bags, plush stuff, toys, other sorts of things you find at gift shops. And in that particular case, which was an opposition, the evidence showed a large number of merchandisers widely using the wording over a long period of time to express enthusiasm or affection for or affiliation with Washington, D.C. So it did not serve as a source indicator for that particular applicant registrant. Another example is the University of Kentucky versus 40O. 40 and O was used, that's a phrase that was used by the university, by people who wanted to align themselves with the University of Kentucky. I think it was in 2015 when they had an almost undefeated season and were hoping to have an undefeated season. And this was going to be used for T-shirts and other sports-related apparel. The opposition there was sustained because of the widespread common use of 40O in an informational manner to convey a perfect undefeated NCAA basketball season. Two more examples, Texas Love as a mark for shirts and hats. That was affirmed because, again, the public would perceive it as a widely used phrase. The evidence showed this, that a lot of people used it. And so the public would perceive it that it merely conveys a well-recognized and commonly expressed concept or sentiment of love for Texas. Once a Marine, always a Marine. This is kind of reminiscent of the Proline case: blacker the college, the sweeter the knowledge. This was basically the specimens there, and the evidence as well of third-party use showed that the public would perceive this particular phrase as just merely expressing support, admiration, or affiliation with the Marines. I discussed the Greenwood case already. Deporter is another one, but this is kind of interesting because this gets into something we're seeing a lot more of, which are hashtags, which are used in social media to gather or to basically focus attention on particular topics. And in that one, it was talking about the Chicago Cubs looking to, after 108 years, win a World Series. And so hashtag magic number 108 became kind of a viral hashtag on what was then Twitter. And the evidence showed that the wording relates to and expresses support for the Cubs and was used by a lot of different people for that purpose, and therefore didn't function as a source identifier for clothing items for the applicant alone. Um, and finally, there's another, like Proudly Made in the USA that we talked about before, investing in American jobs for retail store services was affirmed. The failure of function was affirmed there because the evidence showed that a lot of businesses used that phrase and similar phrases to show, just like the applicant did there, that they too promote American-made goods by investing in American jobs. And with that, I'm going to turn it back over to Judge O'Connor.
Thank you, Judge. So now we'll shift gears and move into some other recent cases on different types of failure to function, with a focus on the key facts to be mindful of when you're addressing such a refusal or trying to avoid one. Falling in the miscellaneous category is the 2023 board decision in Re Mission America Coalition. Here, there was a refusal to register the Table Coalition as a collective membership mark for a group of church leaders promoting evangelism. The issue was, in effect, a mismatch with the specimen. The sole purpose of a collective membership mark is to indicate membership in an organization, and thus the specimen must show use by the members to indicate their membership, not use by the organization itself. The specimens here were a meeting agenda and a business card of an officer, which only showed use by the organization. So this left an application for a mark that may be a source indicator for some goods and services, but not those identified in the application, which had to be rendered and show the membership by the members. Although it's not on the slide, we wanted to give another example, as this too is not a new concept. In the Bose case from 1976, this was a CCPA case, the mark was Syncom for loudspeaker systems. But the specimen showed those goods branded as Inter-Audio, and Syncom only identified the testing computer that helped Bose design the speakers in the first place. Reviewing the statutory definition, the court noted the classic function of a trademark is to point out distinctively the origin of the goods to which it is attached, which means looking to the specimen to see if the matter is used as a trademark for the goods named in the application. Because the specimen only showed Inter-Audio used to identify the loudspeakers, Syncom was not a source indicator and did not serve any other valid trademark function with respect to them. Another type of failure to function is where the matter is mere ornamentation, which can arise for a phrase or a design. In this case, the board affirmed refusal to register "I love you" for bracelets. The critical question was the commercial impression the phrase makes on the relevant public, namely, whether it would be perceived as a mark identifying the source of the goods. Evidence of the size, location, dominance, and significance of the proposed mark, as applied to the goods, showed that consumers would not perceive the phrase as a source identifier. Here, there was also evidence of numerous third parties using "I love you" on bracelets and other jewelry. And in short, the board held, and as you can see in the specimen on the screen, the phrase "I love you" conveys a term of endearment comprising the bracelet, and thus it is ornamental. The next case was an opposition, not a refusal, but we included it to show an exception to this. The ornamentation of a T-shirt or other good can be of a special nature that tells the purchasing public the source of the item, not the source of manufacture, but the secondary source. So here, the opposers' marks all rise, and here comes the judge, as seen on this t-shirt, would not be perceived as mere ornamentation, but would be recognized as marks due to their use with other goods and services, namely Aaron Judge's baseball entertainment services. As you'll see from the next few cases, the board has issued several precedential decisions recently on different types of failure to function. This case involved a proposed color mark for breakfast cereal and highlights the importance of careful drafting of the identification of goods. The board affirmed the refusal here on the ground that the proposed color mark is not inherently distinctive and has not acquired distinctiveness under Section 2F, and therefore does not function as a trademark under Sections 1, 2, and 45 of the Trademark Act. So in this case, the applicant Post had submitted both a consumer survey and evidence of long-time use with crisp rice cereals. The problem was the evidence did not show that relevant consumers associate the colors with applicant alone for any and all breakfast cereals. In fact, third parties use similar colors on other breakfast cereals, and so that was why the mark did not function here. In N. Ray Stallard, the board affirmed a refusal to register a design that consumers would only perceive as a video game character and not as a trademark. Applicant acknowledged here in its mark description that the image depicts a video game character named Maria. That was not a problem because character designations can serve the dual purpose of a character in the work and a source indicator depending on how they are used. The proposed mark seen on the screen was a cropped headshot of Maria. Evidence of use included the specimen, a web page where the game could be downloaded. This page had images of both the full Maria character and another character named Maya. The images of Maria, however, only appeared after those of Maya, and they were buried in the middle of the page. And the examining attorney had gone out and found other evidence, including a listing for the game on Google Play, but that didn't show any images of Maria. So there was no reason for consumers to think that the cropped head of Maria, the Maria character, served to identify the source of the goods. And this case reminds us that it's not enough that the character or proposed mark appear on the specimen in some way. The character has to be used in a way that imparts a commercial impression as a trademark. For the next case, by way of background, even though a performing artist's name may identify and distinguish their music, it doesn't necessarily serve as a trademark for their recordings, which may also bear the brand of the producer. To show that the name of an artist or group functions as a trademark for musical recordings, an applicant typically has to show that the name has been used for a series of recordings and identifies the source of the series, not just the name of the performer. Here, the applicant provided evidence that the name of the band, Boys World, was used on a series of recordings and was promoted and recognized as the source, including through a vast social media following. And the evidence that was introduced here harkens to some of the 2F evidence that Judge Casagrande alluded to earlier, and you can see the extent of reception of that mark and recognition. Moving to another type of failure to function, In re Wood applied the principle that the title of a single creative work, here a book called Church Boy to Millionaire, cannot serve as a source identifier, but instead just identifies the name of that work. Even if it's arbitrary, novel, or non-descriptive of the contents of the book, the name of the book, its title, still describes the book. A title can function as a mark if it is used for a series of works, but each has to have different content. Here, there was no evidence that the proposed mark was used for a series of books. Applicant did present evidence of a second Spanish language version of the book, but that version did not make any significant changes to the content, and so the refusal was affirmed. In addition to examples of different types of failure to function, we wanted to review a few cases where the refusal was reversed, which can be helpful if you're trying to overcome a refusal or, again, avoid one in the first place. In Ray Black Card involved the mark Follow the Leader for a variety of credit card and travel-related services. And the board, again, reviewed the evidence as a whole, which showed many uses in the marketplace and in general. And these ranged from a children's game to business principles with varied meanings in those different uses. Although the evidence showed common use of the phrase in various contexts, it did not show that the phrase had a generally understood sentiment or meaning, such that consumers would not perceive Follow the Leader as identifying the source of the applicant's services. And therefore, the board reversed the refusal. Over the past year or so, there were two other reversals of note at the board. First is the In Ray Lizzo case for the phrase 100% that bitch, which had been featured in one of Lizzo's songs, and she applied to register the mark for various clothing items. The examining attorney refused registration, submitting evidence of wide use on the phrase to convey an ordinary sentiment. And this evidence included ornamental use on T-shirts, hats, and other goods. Applicant, however, parsed through that evidence and discerned that most of it actually referred to Lizzo herself or her song. Thus, the phrase did function as a source identifier for the applicant's goods, with the board concluding that most consumers would perceive the mark as associated with Lizzo rather than as a commonplace expression. And even though the phrase had originated by someone else in a meme, Lizzo still was the one with whom it was associated in the marketplace most prominently. Also, the 06 case was a reversal where the board found that applicant was able to show use of the band name Boys World in connection with a series of musical recordings and that the band was promoted and recognized as the source of those recordings. And now Judge Casagrande will take a look at a few areas where failure to function relates to other grounds for refusal.
Thank you, Judge O'Connor. The failure to function does relate to other refusals, and there are some refusals that you might think it relates to that it does not. For example, I mentioned earlier that it relates to its merely descriptiveness refusals in that a merely descriptive term, that is a species of failure to function, and it's one that's specifically provided for in Section 2, in part because Section 2 also provides that there's a means to get around a mere descriptiveness refusal if you can show that the phrase otherwise merely descriptive has acquired distinctiveness. Also, another type of failure to function that you know by name from common cases, and it's also mentioned elsewhere in the Lanham Act, is genericness. Now, genericness, when you see a genericness refusal in an application, you will see that it cites sections 1, 2, possibly 3, and 45, which are the exact same sections as a failure to function refusal. And that is because genericness is a type of failure to function, a very common one. And so it's got its own sort of case law that's come up that defines what genericness is and how to discern whether a mark is generic for the goods or services. The Trademark Act, Section 2E5, also talks about things that are the components and matter that are functional. This, even though the word failure to function has the word function in it, a functional refusal is actually not a type of failure to function in a couple of respects. And number one, the functionality refusal actually finds its genesis in Article 1 of the Constitution in the Patent Clause. It's not something that finds itself, that finds its roots in the definition of a trademark. And that's in part because a functional component or functional matter is defined by what it does, not by what it communicates and how consumers will perceive what it communicates. It's a very different kind of thing. So there are also some application requirements that sometimes are overlap with failure to function, and that is when there are drawing requirements or specimen requirements that have to do with whether or not something that is depicted in a drawing or shown in a specimen does in fact function as a trademark or service mark. As I mentioned before, when I was going through some of the historical development of the cases, you'll see that there is some uh, proximity and even some overlap between mere descriptiveness refusals that are very commonplace and the failure to function ones that maybe don't have the same developed body of case law as mere descriptiveness cases. So, for example, think of the phrase in the Melville Court, brand names for less. That sounds like it could be descriptive of retail store services. And the same with walk-in, phone-in, login for retail mail order and online retail store services. And that was a non-precedential case. But those are examples where there is overlap between the two types of refusals. Again, there's proximity is not necessarily the same thing as overlap, and you can have cases where it gets close, but maybe is not exactly a failure to function, or is not exactly a descriptiveness case. So this is an example that you make it, we make it, you bake it for supermarket services was an example where failure to function was correct, and 2E1 was not. And the same for why pay more for supermarket services. There's a recent case that the board decided in which there is going to be overlap with failure to function and both mere descriptiveness and potentially genericness, and that was the sheet pile case, where the mark there was Z pile for metal sheet piles that were to be configured by the person buying the sheet piles a particular way in what was known as a Z pile configuration. And there, the board affirmed the refusal that was on the mere descriptiveness ground. There was an alternative refusal for failure to function in that case, but the board did not reach it and rested its decision solely on the 2E1 refusal. Generally, when there's overlap with something like mere descriptiveness or genericness, the general rule, I think, of thumb that examining attorneys and the board tends to follow is where that specific subtype of failure to function, genericness or mere descriptiveness, is something that is the refusal that was made and the evidence supports that, that's the preferred way to treat the case. Because the distinctiveness continuum includes a threshold bar for registration of generic terms, terms that by definition fail to function as source identifiers, this continuum, rather than an informational matter failure to function refusal, provides the appropriate framework for the assessment of registrability based on the rationale articulated by the examining attorney in this case, i.e. that the goods at issue are Z-shaped piles. And that was a quote from the sheet pile case. But again, there will sometimes be cases where the evidence is not clear where these particular things fit, and maybe both fit. And now I'll turn it back over to Judge O'Connor.
Thanks, Judge. So here we have another case illustrating the interplay of different types of failure to function. The proposed mark was no more rhinos for goods including stickers, t-shirts, and the like. The board affirmed the refusal because the designation was merely ornamental and informational matter and did not function as a mark for the goods. The examining attorney submitted evidence that no more rhinos is a political slogan, meaning no more Republicans in name only. And there was evidence that it was widely used on t-shirts and other items, and that consumers were accustomed to seeing the phrase on goods from many different sources. So the board considered the specimens, which were photographs of items like bumper stickers, and each of them displayed the proposed mark in large, prominent lettering in the center. The placement, size, and dominance of the wording are consistent with informational or ornamental use rather than signifying a brand, and the board affirmed. And similarly, as we've noted, the significance of a phrase is considered in determining whether the proposed mark is merely ornamental. And so these two types of failure to function may implicate the same evidence and in some cases overlap. And here we have two other cases illustrating this. So in Proline Corp, which Judge Casagrande talked about earlier, the phrase blacker the college, sweeter the knowledge was used ornamentally for T-shirts. The specimen showed prominent use of the phrase, which itself conveyed a message about the value of an education at certain schools, and determined that it would be perceived as a primarily ornamental slogan. The more recent case of Peace in Ray, Peace, Love, World Live reminds us that mere ornamentation and informational or common phrase are separate reasons for a failure to function refusal. So there, the examining attorney refused registration based on mere ornamentation, but noted that I love you appears to be incapable of functioning as a source identifier. Later, on appeal, the examining attorney argued both that the phrase was merely ornamentation and a widely used informational message that could not function as a trademark. But because it was not clear that applicant had had a full opportunity to address the informational message ground during examination, the board expressly limited its review to the merely ornamental ground and considered the significance of I love you only as a factor in assessing whether the merely ornamental refusal was correct. The next case illustrates the common pitfall of a mismatch between the proposed mark and other aspects of the application. So here the applicant provides bus tours in New York City called The Ride, where the bus pulls over and people who are really actors on the street perform and interact with the bus as a means of entertainment. For example, a person in a suit standing on the street might break into a tap dance. Applicants sought to register the matter seen in the drawing and on the screen for conducting sightseeing travel tours by bus in Class 39. As you can see, the drawing showed two freeze frames, and the description referred to the live visual and motion elements of the trade dress of a guided bus tour. So the examining attorney refused registration on several grounds, namely failure to function despite a claim of acquired distinctiveness, that the specimens did not depict the scenes that were shown in the mark drawing, and that the description of the mark was incomplete. And the board affirmed on all three grounds. So 2 points are of note here. One, again, the mark description, drawing, and specimens did not align with each other. For example, the description did not state whether the mark was three-dimensional trade dress. And the applicant had survey evidence which showed that consumers associate this type of a bus tour with the ride, but the surveys did not show an association with the applied for mark, which is the design, again, shown in the drawing. So in short, the evidence showed that the tap dance routine would be perceived as part of the services and not as a source indicator for them. So from these cases, we can offer a few overall takeaways and practice tips as we conclude our presentation. First, in an appropriate case, consider whether you have evidence of acquired distinctiveness. As we've noted, this doesn't apply in all cases, and it can be a heavy burden. And the same evidence, however, can help to show that the matter functions as a trademark. So a good example of that was the Boys World case where 06, where they presented a lot of evidence of recognition. Another option is to argue that the matter is merely descriptive and then either make a case under 2F or amend to the supplemental register. For mere ornamentation, consider whether you have evidence that the matter is a trademark for other goods and services and thus indicates a secondary source. For characters, advise clients to use the designation as a source indicator. So taking a look back at the Henry Stallard case, you'll see some examples of how you might do that, but it can include prominent, consistent use, which were lacking in that case. And you would want to make those obviously in ways that are typical for brand identifiers. For titles of books and other creative works, seek evidence of use in a series and remember that the content must change significantly. So a translation to a different language or just a mere change in format is not enough. And with that, Judge Casagrande will share a few additional thoughts.
Thank you, Judge O'Connor. The main takeaways that I want you all to take from this, and some practice tips I think that could be useful. The main takeaway is that failure to function actually is a statutory refusal. Section 45 defines the function of a trademark, and it defines it in terms of communicating one particular thing, identifying and distinguishing the goods and the source of those goods. If something that you're applying for a trademark for primarily communicates something other than that, then by definition, it doesn't function as a trademark. So when the refusal for failure to function typically will issue when the evidence shows that the proposed trademark is perceived, for example, as a common phrase or widely used message, or in some other way that is not source identifying. And the evidence I'm talking about is both based on third parties using it and the evidence of what that shows is out there in the marketplace, and also evidence based on how the applicant themselves use it. So if you're prosecuting an application and you're an applicant, if you can provide evidence showing use and recognition of the phrase or whatever other matter that you're seeking to register as a source identifier, and that it's substantially exclusive to you, that's going to go a long way to overcoming evidence that maybe some other uses are out there in that the examining attorney found on the internet. But it's got to show primarily that people will identify it as a source identifier of the applicant. Another practice tip is to counsel clients in both selecting and developing marks, and also in using them consistently. And so when I say selecting, one of the things that we've seen are that things that are viral or memes on the internet or on social media that are by definition used by lots of people perhaps are not good candidates to try to serve as source identifiers for one particular party's goods and services. But once you do select a mark and you're counseling clients about how to use it, make sure too that they use them consistently in a source identifying manner and not as in the situation in some of the cases I mentioned where you're using other things as the source identifier and using the phrase in the application in what is clearly a non-source identifying manner. Third, be mindful of a mismatch between the proposed mark and the identified goods or services and what your evidence, such as your specimens of use and other advertising and things of that nature, show. Because as in the Bose case, you may be using a mark for one thing and it's the subject of an application for something else. And there's a mismatch there, and therefore the mark does not function as a trademark for the thing that's identified in the application. And in an inter partes case, if you're an opposer or petitioner, you obviously want to show evidence that shows that the matter that is at issue is used extensively or in common use by third parties, that consumers are going to perceive that use and primarily not view it as a source indicator to whoever the defendant is in the case. And such evidence would be, is the phrase being used not as a source identifier, but as, for example, a common phrase or expression, something that people want to align themselves with or show support for, things of that nature. And now I'm going to turn it back to Marisa, I think, for questions that may have been come in while we were doing our presentation.
Yes, sir. Thank you so much, Judge. I appreciate you and this wonderful presentation. Thanks so much for guiding us through so many precedential TTA decisions pertaining to the failure to function refusals. And thank you both for taking time to distinguish the failure to function refusal from other refusals. All of this has been very, very informative. For those of you who have downloaded the slide deck and have navigated all the way through it, you're going to notice if you look at the notes section that the full case citations can be found there. So in case you're wondering, you want to see those full citations, they're right there. So at this point, I'd like to invite questions from our audience to help broaden our discussion a bit. We've got plenty of time to kind of navigate through. And so we're going to start off with a question for Judge O'Connor. Okay, here's a question for you.
Mhm.
Can the failure to function refusal be issued before a specimen is submitted? What do you think?
That's a great question, Marisa. Thank you for that. Um, so the answer is sometimes yes and sometimes no. And as we've talked about, the failure to function refusal is typically specimen based, but it can be issued if the evidence supports a determination that a proposed mark is, for example, merely informational. And so there are a number of examples provided in the TMEP. There's some recent cases and some recent non-precedential cases where this has come up. And it also can come up when the application is based on a foreign filing where you don't have a specimen or may not have one before the mark registers. So for many of the grounds of failure to function, or at least some of them, the refusal can be issued before a specimen is submitted. And that would be based on the mark itself, perhaps the mark drawing, if there is one, the description of the mark, and then evidence that the examining attorney may find in the marketplace.
Okay, so sometimes yes, sometimes no. Thank you for those two good examples there. This is the question for you, Judge Casagrande. Here's your question. What is enough for an examining attorney to refuse for failure to function due to being a commonplace or widely used message? So I guess we're talking about evidence here a little bit.
It sounds like it.
Mhm.
I would say, and that's a great question. I think lots of people are wondering about that, I don't want to be sort of flippant about this, but it's just like any other refusal.
Okay.
Like any other refusal, all the examining attorney initially needs for that initial refusal is enough evidence to set forth what is called a prima facie case, and that is evidence that provides a reasonable factual predicate for the refusal. So that then there's a chance for the applicant to come back with evidence to counter that and maybe show that it does function as a source identifier. And then there will be a back and forth with the examining attorney. And the ultimate question then becomes, what does the evidence in total show? That it's primarily viewed as a source identifier, or that it's primarily viewed as merely informational or a commonplace message? So, I think it's hard to give a specific answer, but I think many of our listeners probably can recognize that they've gotten, for example, certain 2D refusals where there's a lot of evidence in the initial refusal, and then there are others where it's very simple and there's not very much, and then basically the record gets developed as you go back and forth with the examining attorney, and then ultimately the decision is made in the final refusal or the allowance.
Okay. I'm going to jump back over to Judge O'Connor with a question for you. Here's one. Can an application be refused for failure to function if the specimen shows the mark displayed on a hang tag, such as a t-shirt. So talking about t-shirts, okay, and the hang tag on them.
So yes, it can. And thinking about this, we've seen some cases with this type of evidence, um, but generally, as we've talked about, all of the evidence of consumer perception has to be considered. So that includes evidence of use in the marketplace, both by the applicant and third parties, use in media, any other use that is available. And so the hang tag or use by an applicant on a specimen in that manner would be one piece of that evidence. So the question really depends on whether, from all of the evidence as a whole, the proposed mark would create the impression as a source indicator or something else. And
Mhm.
so it can be perceived as something else, even if it's displayed on a label or a hang tag. And I think in some of the cases that we've discussed, there was such evidence and it didn't overcome the other evidence. And this is kind of a place where we also remind, ourselves that applicants' intent and their efforts to use it as a trademark, so putting it on a hang tag, are not controlling, and the application can still be refused if the evidence as a whole shows that people don't associate the proposed mark with one source.
That's a good point because typically you're trying to not get an ornamental or ornamentation
Right.
refusal, so you're going to make sure that the specimen shows the hang tag because you're thinking, okay, that's a surefire way, but maybe not always. So thank you for that.
Mhm.
Okay, very good. Go back up to you, Judge Casagrande, with another question for you. Um, why do you think failure to function refusals seem more common in recent years? I don't want to lead you, but do you think
Mhm.
that they're more common in recent years? These failure to function refusals. Seems like we're seeing more of them.
It seems like that to me too. I
Hmm.
don't have statistics in front of me, but I do sort of qualitatively share that observation. And I've thought about why that might be. And so sort of just anecdotally or observationally, my own theory is that I think it has in part to do with the growth of social media and internet memes and how that sort of kind of interacts with the growth in commercial on-demand print companies, things of people trying to commercialize things. And so I think a lot of people sort of, with those two things coming together, a lot of people end up applying for things that are not necessarily associated with one particular source. They're all sort of racing to be the first to, get a registration for a particular meme or a particular interesting viral thing on the internet. And I think one of the things that, that I would like people to understand, and maybe advanced, practitioners like who are the audience here already know this, but I think a lot of people in the general public don't, is that there's sort of an inherent tension between a meme's popularity, which means that lots of people are using it, and the function of a trademark, which is to identify and distinguish a unique source of goods and services. And I think, the fact that there's that tension there and the growth in the kinds of things I was talking about really, at least to me, seems to explain why these seem to be more common these days.
Hmm. Yeah, I agree with that as well. Just seeing just the way language is changing and how we are like using these terms differently in this new interface. Not so new now, but in this social media landscape. Judge O'Connor, did you want to weigh in on that too? Did you have an opinion you want to add in with regard to that question about whether the failure to function refusals seem more common?
Well, I'll just echo what you had just said, which
Okay.
was the changing of language. And even though the internet is not new anymore, and social media has been around for a while, it is continually changing and evolving and growing. I mean, now we have TikTok and we have so many more things out there. So I think that probably is one of the reasons as well.
Which is why we love trademark law, right? It's
Mhm,
very exciting because we are always sort of racing after what's happening
mhm.
in the world. So that's kind of fun. Maybe the law will change and kind of catch up. We'll see. So thank you very much. Okay. We know that we've been receiving questions before the event and during the event. So I want to make sure that we spread the love and kind of get everybody into this conversation. So I know that TN was a brave soul. I think gave us one of our first questions of the afternoon. So we want to make sure we um, sort of amplify this question. So both of the judges, I'm going to be looking at you to let me know if you want to answer this. But here's a question: how can we search the same ground cases in like at TTA view? Okay, is there a way to sort of search these kind of grounds, sort of seminal cases in TTA view, or should we be is there a way to kinda use, TTA, the TTAB reading room? Are there different ways to search for different things?
I'll just take a quick stab at that. I don't do much searching through the
Okay.
TTAB reading
Right.
room, but I do know that you can search through the decisions that way for particular words, and so maybe that is a way to do it.
Okay.
I know that there are lots of paid legal search services like Westlaw, Lexis, and the
Sure.
like, Bloomberg, that you can do searches that way. And I think there are still some free um, legal databases that may have some TTAB decisions. So searching that way, sort of the typical way you would do in a Westlaw search, might be the way to go. But again, I'm sorry, I'm not super familiar with
Oh.
how to navigate the reading room looking for particular concepts.
Sure, I understand. I think Tien was sort of trying to, if I look to the second part of this question, trying to figure out a way to search cases, finding certain goods and services, I guess, as they're trying to do that type of search. Judge O'Connor, do you want to add anything before we move on? Nope.
I would just say that that
Okay.
was what immediately came to my mind as
Hmm.
well, was to use the keyword searching, which I
Yeah.
think is available in the reading room. And I know you can search other criteria such as the grounds. I'm just not sure if failure to function is listed there, but the
Okay.
keywords should get you off to a good start. And then you can always consult the TMEP, which will have selected case citations as well.
Okay, all right. And I think that link to the TTAB reading room might be provided in our chat thread as well if folks are looking for that. Okay, thank you. Now, Liz kind of gave us a bit of a maybe the answer to a question, but I want to flip it around a little bit and see if I can turn this into a question. So she's asking, can 2F evidence of acquired distinctiveness be used to obviate a failure to function refusal, informational matter type of refusal? And I think we kind of mentioned it as you discussed the Henry Post Foods case, maybe.
And I can take it, I think we both
Okay,
touched on that a little bit, and
wonderful.
if it's okay, I'll take the first stab at it. As I mentioned in during the slides, while for most types of failure to function refusals, a showing of 2F will not get you over the hump legally. The type of evidence that you would typically want to show in when you're trying to make a 2F case is going to largely be relevant to showing that the particular mark is not failing to function as merely informational or something like that. Because that is evidence that goes to how your client has used it, how much your client has used it, what sort of feedback have they gotten from third parties? Have articles mentioned it? Are there lots of comments and likes on various social media that your client may have? All that sort of stuff, and even surveys. You could do surveys, although that's sort of a brave new world for failure to function. But I know there are some articles out there on that. Those sorts of things can go a long way to showing that consumers will perceive whatever the phrase or matter is as a source indicator and might overcome some other evidence that shows that third parties are using it. It all depends on how much and how convincing that showing is. But that, again, it's not a legal showing of 2F, but that sort of evidence can be relevant to consumer perception.
Okay, thank you for clarifying. Uh, Judge O'Connor, any comment?
I don't think I have anything to add to
Okay.
that. I
Well,
would agree with
wonderful. No
Judge Slade.
problem. Okay. All right. Let me circle back to that other question. We were talking about the TTAB reading room. So we've got a lot of great helpers that are participating with us today, and one of which is Cheryl Butler, who's a senior attorney at the in the TTAB. So the clarification is that you can absolutely search in the TTAB reading room by refusal, and that does include sections 1, 2, 3, and 45. So in case we've got folks out there who are just curious and wanting to get a little bit more, let's clean that up right away. That is a ground or a claim that you perfect. Okay, so let's move on to another question, and this one was provided by Peter. This is the question, and so either of our experts here can weigh in. The question is, could you discuss a little bit about the use of the laudatory words such as advanced or superior as the first word in a mark, where the rest of the mark is so highly descriptive it's usually disclaimed? I guess Peter is sort of thinking about the times when he might have seen some of those allowed under Section 2F and sometimes without 2F. So maybe there's in his mind maybe a bit of inconsistency. I'm not going to put words in his mouth, but the question is maybe giving us a bit of your opinion on that, maybe discussing that.
I'm reading the question
Please do, yes.
as primarily not, focused on failure to function,
Hmm.
but on 2F and highly laudatory terms. And a couple of thoughts come to mind.
Thank you.
There are sometimes failure to function refusals that are based on terms that are being used in the context of the overall use on a label or in advertising. And I'm thinking, for example, of the case, we make it, you bake it, things like that. If it's used in a way that is just conveying information, and other things are being used as the source identifier, then that might be something that shows that it is not functioning as a trademark. And an old CCPA case that has something similar. Apologize for not remembering the name of the case, but I think it involved the phrase consistently superior. And I think the court in that case said it was being used in a way other than as a source identifier. So it wasn't that, wasn't being refused as highly laudatory because that was the mark, but it wasn't, was too descriptive. It was being refused because in the context of the overall label, it was not conveying source.
Okay. Um,
I don't know if that it answers the question, but
I thought that was very helpful. Judge Casagrande, I'm going to give you an opportunity to add your few words if you'd like.
Oh, yeah, I think that obviously it's going to really depend on what the second word is. I don't think
Of
there's a
course.
general rule that advanced or superior is or isn't capable of being part of a mark that can serve as a source identifier in short. So, but it's a good question, and certainly some of the marks that we've looked at, the best beer, that kind of thing, do really illustrate the fact that it can be part of a mark or a proposed mark that does not function, depending upon what it's combined with,
Okay.
how it's used and
Hmm.
perceived.
All right. Thank you. Thank you for that. Let's pop over to Lisa. Lisa has a question about a slogan or a tagline and wondering about the registrability of it. If it's not commonplace, would they still be refused under failure to function? And we know we can't give definitive answers here. This is just a conversation amongst colleagues, okay? But so I'll say it again. What makes a slogan or tagline registrable? If it's not commonplace, would they still be refused under failure to function? Slogans, by their nature, are somewhat descriptive, and I've seen many registered without an issue that are similar to some of the examples you've used. Does anybody want to take this one?
that calls to mind to me a little bit the medic alert case that I talked about early in the presentation,
Okay.
where maybe that wasn't something that was there. I don't think the evidence there showed that it was commonly used, but the
Mhm.
evidence there showed that the way it was being used in relation to the goods and services was not, as a mark, but merely informational in that the people wearing the ID tags that were the goods in the case, were disabled and needed particular medical attention, if they were found or, in an accident or something like that. So that's one I think where it wasn't necessarily in commonplace use, but in the context of the goods and services, it was merely informational.
Okay.
I would just add that for slogans, obviously it's a very subtle analysis of whether it's any of these grounds of refusal apply, whether it's merely descriptive, whether it's only laudatory or fails to function in the first place. So it's a close question in a lot of cases and very subtle, and obviously depends a lot on what the goods and services are and how it's used. So it's a great question. We thank you for raising it. I wish we could answer it definitively again, but we hope that we've given you some of the concepts to think about when counseling clients and guiding them with this.
Okay. Thank you. I think so. I think we've given folks a lot to think about today. So thank you for that. Okay. So I think we've got two questions that sort of maybe somewhat related, but let me just kind of ask this broad one. This is from Leslie asking about would translating an existing registered mark be a reason to refuse for failure to function? I see lots of other refusals circling in my mind, but would translating an existing registered mark be a reason to refuse for failure to function? What do you think? I think this might give us a way to kind of have a larger conversation about refusals in general.
I guess it depends, if it's the same registrant, I wouldn't see an issue with that. uh, unless it was one of those cases where the foreign registration, the registration in a foreign language maybe wasn't refused on the basis that it was merely informational, and that becomes apparent in a new application for the English translation of that. So there's a possibility that that could happen. Um, but if it's a different party
Mhm.
applying to translate someone else's registration in a foreign language, that definitely would raise 2D likelihood of
Mhm.
confusion flags, depending on what the goods are and the services are, obviously. But that would certainly be, the first thing that pops into my head.
Right, because that likelihood of confusion refusal, one of our most popular refusals that we issue, is always something to consider. So, we have done so much work on training folks up on a new search system so that we can be aware and hopefully somewhat predict some of those refusals before they're issued. So, thank you for reminding us that yes, there are other things to worry about besides failure to function, though that is the topic of today's conversation. Now, Kevin sort of has a similar sort of twist on that same type of question. He's asking, can a slogan that spells words differently from the common spelling or includes like a design element have a better chance of avoiding a failure to function refusal? And again, it's a similar type conversation. Did you want to say anything different here?
But I'll begin. I just it generally and I think you've probably seen this concept in um, TTAB decisions regularly. If something is basically just a mere misspelling of something that otherwise is apparent from just reading what it is, that generally will not obviate the kind of refusal you'll get for it doesn't obviate 2D refusals. I don't think that it obviates 2E1 refusals. And I think similarly, if you can just see that it's a misspelling of something that is a commonplace or widely used message, unless it's pretty different, I don't think that's going to get you over the hump.
Okay, I'm looking at the clock. I think we have time for maybe one more if we could sneak it in before we close out. We will end on a positive note from Thomas, who believes that this has been fantastic content, and I agree. All right, but he's thinking would love to hear a little bit more about the overlap of genericness and functionality as opposed to failure to function in the context of cancellation, particularly with incontestable status. That's a lot. Does anybody want to take a bit of that as we scroll on down to the end of our time today?
Um, I'll take a little stab, and then maybe Judge O'Connor has some thoughts. I'm
Okay.
not sure exactly what Thomas is getting at.
Okay.
Two things kind of hit me. Number one, I mean, genericness and functionality. Those are things I think that you don't usually see together. Um, it's certain product configuration marks. That's usually what you see when you're thinking about functionality, but we also are familiar with product configuration marks where there have been genericness refusals, such as the one involving the handbag. I think it's called Jasmine Larian. That was a genericness refusal for a product configuration mark that wasn't necessarily functional, but it was triggered by the product configuration itself. But in terms of overlaps between genericness and failure to function, or functionality and failure to function, I think, as I mentioned, there is potentially overlap between genericness and failure to function, in that genericness is a species of failure to function. And I think the general rule the board follows, and I think examining attorneys do as well, is because there's this very well developed and familiar body of case law for genericness. If that fits, that's the shoe you're going to wear. Um, but sometimes it won't be very clear, and there might be refusals in the alternative. And it really just all depends on the evidence and what the marks and the goods are in a particular case. And it's kind of hard to sort of parse them in a way that's gives you very bright lines. In terms of functionality and failure to function, as I mentioned before, I really think there is no overlap there. Those are two entirely different concepts that really, functionality is what the thing does. What does the matter do? Does it functional? Does it improve the particular thing that it's a part of? Whereas failure to function is all about what do consumers perceive as this thing as communicating. And those are two very different things.
Thank you for that. Thank you very much. Judge I'm sorry, Judge O'Connor, did you want to say anything else before I sort of close us out of this presentation? This has been such an informative presentation. I have learned so much and have been reminded of so much that I need to brush up on. So thank you so much for that. But anything you want to share before we close out?
Just to thank everyone for the really thoughtful questions. The last one in particular, I think my colleague answered it well, but
Yes.
to thank you all that these are some challenging and very interesting issues. So thanks so much for your participation.
Okay, so I'll bring everyone's attention back to slide number 7, which sort of lays out the types of failure to function refusals we've been talking about today, and just things to keep in mind, and sort of a great like sort of overarching listing. So before we conclude, let me just thank everyone. Thank you, Judge Casagrande and Judge O'Connor, for leading our discussion today. I also want to thank my manager, Jason Lott, and Cheryl Butler for assisting in the background. Okay, we couldn't have done this without you. Jason Lott is the managing attorney in the Trademarks Customer Outreach Office at the USPTO, of course, and Cheryl Butler is a senior attorney at the TTAB. Finally, let me draw your attention to a few more reminders. Around 3:30 p.m. Eastern Time today, you will receive an email that contains the following: a link to our survey. I'm telling you, it's only going to take you 3 to 4 minutes. Please, we'd love to hear from you to get some feedback on what's working and what's not. You'll also receive another link to the presentation slides. And if you're curious about when this recording of this presentation will be available, it will be available in about 3 weeks or so. You'll find it on uspto.gov and also on YouTube on our USPTO channel. My name again is Marisa Terrell. Thank you so much for joining us today. Please visit our webpage for information about our next Experienced Practitioner webinar event. Take care.